Good afternoon, everyone. Welcome to Electronic Frontiers Australia's EFA Talks. My name is Angus Murray. I'm the Chair of Electronic Frontiers Australia's Policy and Research Committee, and I'm looking forward to our conversation with our guest, Lyndsey Jackson, Chair of Electronic Frontiers Australia today. Before I begin, as a couple of brief sentiments for myself, firstly, I wish to acknowledge the traditional custodians of the land that we're meeting on from various parts of Australia, and to our international people joining us, recognition of the Australian community being the longest standing connection to country in the world. I acknowledge the elders, past and present, of those communities and the wisdom that they have shared with us and continue to share with us. As with previous EFA talks, there is a chat facility and a Q&A. If you have questions that arise from today's session, feel free to pop them into the Q&A or into the chat, or send us an email afterwards, and we're happy to answer further questions. Today's discussion is again quite topical given recent developments with respect to class action litigation and the Robo debt saga. I'm pleased to have Chair of Electronic Frontiers join us, and she's been heavily involved in this space for many years, alongside a number of other colleagues across a variety of organisations. And this really has been a collective push on a very difficult and interesting subject matter. Lyndsey has been active in web and digital media for 10 years. She's a committed advocate of the protection of individual rights and works to facilitate accessibility for people with disabilities and to ensure the use of digital does not create procedural or administrative issues that contribute to unfairness or disadvantage in society. When speaking nationally and internationally on digital rights, Lyndsey focuses on the need for equitable citizen access to technology and on the engagement of non-technologists in technology and accessibility matters. It is an exciting and interesting challenge and time for digital rights, both nationally and internationally. And there's a lot to be gained through collaboration, shared education, and broad conversations. As Chair of Electronic Frontiers Australia, Lyndsey has been committed to building these relationships internally with members and externally with the wider committee. She's fostered collaborative movements and been heavily involved in a large number of projects, including NetThing recently, which was an excellent event. It's great to have Lyndsey here. These conversations, I don't think Lyndsey and I have had recorded our conversations in the past, but I've certainly had the great fortune of many conversations over the years with Lyndsey about all things digital right. And I know that this particular topic of robo debt is particularly close to her heart. So thank you, Lyndsey.
Thanks for having me.
I think the best way to do this is to just jump straight into the discussion. And obviously the topical point at the moment is the announcement that came at the end of May. The federal government had conceded the class action relating to the use of automated debt recovery tools within its Centrelink or Human Services Department. And there was an agreement reached to pay approximately $721 million to people who have been subjected to robo debts. Although I've read today that that number may actually be an underestimate. Lyndsey, you've been heavily involved in this, and more so than me, right back to the beginning of 2016. So could you tell us a bit about this robo debt and what that means?
Yeah, so functionally, Centrelink used to have people that would look at debt that form the debt recovery program, where they would manually go through people's information. They would reach out, Centrelink would reach out to employers, and they would ask for pay slips, and then they would do internal calculations to see whether or not people had been overpaid or underpaid, or overpaid, actually, never underpaid. So they were able to do about 20,000 of those a year. And then with RoboDebt, what they started to do was to data match against the ATO data. So they would take Centrelink data, and then they would take the Australian Tax Office data, and match that together in a very crude way. One of the main things that was occurring with that, which is the thing that's particularly been found to be illegal, is an averaging of the Australian Tax Office data. So if you earned $52,000 in a year, then it would average it out to say that you earned $1,000 a week. And therefore that $1,000 a week for people would often throw up debts, particularly if, say, they were on Centrelink for part of the year. So say studying, and then they left Centrelink, they got a full-time job, and that's when they were earning the bulk of their money. So it was disingenuous that at any time when someone was on Centrelink that they were getting $1,000 a week from they're effectively saying that people were defrauding the system. That was the analysis that comes from the data averaging. Other things that would occur just because the data from the taxation office didn't have to match the data that Centrelink had. You might have the ATO with an employer name that was slightly different to the version that Centrelink had. So it might be something like Centrelink has Jeans West, but the ATO has Pacific Brands Group. So there's nothing incorrect, it just doesn't match. But then when you do try to get that data to match, it looks as if the person has had two employers. So then the calculation for what they should have been earning and whether or not it was accurate, again, says that, infers that the person receiving Centrelink benefits was lying. So those sorts of, and then there would be, because the systems are old, there'd be a range of other things like duplication of people's names, or we'd see people that, we'd see another Lyndsey Jackson, and then all of a sudden they've got my details are combined. So a whole bunch of stuff like that, because the ATO didn't have to keep the same degree of accuracy. So then when you try to data match, anything becomes inaccurate. And so when you've got a human that's over it, they're looking for those triggers, and they can see, actually, no, the date here is right, the date here is wrong, we can ignore it, it's not an actual date. When they took people out of it and they automated it, they were able to start doing thousands of these debt recovery letters, sending them out, demands for debt per week. So functionally, that was what was occurring, and you could see that on paper for a department that is tasked with recovering money and contributing back to the budget and fixing the budget bottom line, that looks very attractive. They did a sample of 1,000 people, and they found in their testing, and when they kind of tweaked the letters and tweaked the system, that if you got a letter from the government 5 years out of the blue, so this is the other thing, like this data matching was occurring and asking for records 5, 7, 10 years back. But if you got that letter that said, 5 years ago you made a mistake and now you owe us money, people paid because it's a letter from the government. Of course you must have done something wrong 5 years ago, and you're at uni or whatever, you can't really remember it. So the campaign around Robo debt was, and what's been the most effective, has been this huge community conversation or community movement, with lots of different groups and lots of different voices that kind of have come together to unpick exactly what was going on, and that really started on Twitter, and so you saw key people, and particularly key people that have been very heavily involved in the digital rights scene for a really long time, because this is one of those points at which technology and digital rights intersects with government administration and people and humanity and the rights of people. So very much a space that digital rights advocates have been saying for a very long time is where these issues will occur with technology, and the mass harm that these sorts of technologies can create. So you had strong campaigners and activists and journalists such as Asher Wolf, Justin Warren, who's on the board of EFA. Everyone taking their key strengths and the key bits that they did the best and working on those things. So for example, Asher, the level of research and knowledge and depth and information sharing and curation of that information. Justin Warren getting freedom of information claims from freedom of information files from the government. That really allowed and has sort of drip fed over the past 3.5 years, people to get to a real understanding of at which point these policy things were implemented, even as far as like the risk management frame that allowed the department to think that this was a good idea, kind of leading back to 2015. So we were able to see the history of how this program came to be. So people like him. People like lawyers and Victoria Legal Aid, who launched the first litigation into this, the social service organisations, ACOS, and all of the different councils of social services in the area, in each state, supporting people, because as the people are starting to get these letters, it's becoming more and more confusing about what the issue is and whether or not they've owed money. And then you've got people themselves that have had firsthand experience that are also really, really bravely and really critically sharing their story and building community. So I guess my piece within that was to help build a website that allowed people to share anonymous stories. And when we had those stories, we had information on the impact, the human impact that this was causing. We also had content that we were able to share. And there was that ability for people to be able to contribute to the conversation around it, and let us see the extent to which this was occurring. So that website, we pulled together a group of volunteers. There's still a really strong core of volunteers that even today provide support through Twitter, Facebook. Our Facebook group and the Facebook support has been huge and has allowed us to individually kind of provide awareness on people's rights and the different mechanisms that people can go through to get to the bottom of their debt. So the freedom of information requests that an individual can make, the different administrative steps such as the Administrative Appeals Tribunal, the first level, the second level, how to get through that. So just even having that really strong community support and coaxing for individuals that feel really alone and really under-resourced, or they don't, it's not like you can ring a lawyer for these small amounts necessarily. People don't have the capacity for that. A lot of the legal aid and community legal centres were able to help with it, but really is that their role? So there was limitations to what they can do. So that kind of people power and community supporting each other at all levels through this campaign, as it was unpicked, has been really critical.
It's been a Herculean effort across a very large number of people, as you said, Lyndsey, which in many senses is a sad reality that sits, given it seemed to be a fairly straightforward series of issues that were at play here. I've had a couple of questions come through to similar effect, and I might try and roll them into a single question. I understand digital rights to effectively be human rights engaged in a digital environment. So human rights is engaged in a online space or in the connection of computer space. To me, it sounds like this might be more than a digital rights issue. And personally, I've taken issue with the government's selling of this in July 2016 as a saving. I can't see how this was ever a saving. It's a debt recovery tool, and it was particularly problematic because it was targeted towards people who inherently, by the nature of the payments they were receiving, were at a disadvantage. The social harm this has done, I think, is enormous. The receipt of a debt notice, some of these being in tens of thousands of dollars, by a person who can't access a lawyer, isn't aware that there's recourse, and is otherwise disadvantaged because of the situation they're in, where the government should be assisting them out of that situation rather than forcing them further down. To me, it seems like there are digital rights issues in the context of potentially under the General Data Protection Regulation, Article 22 puts a prohibition on people being subjected to automated decisions other than where there are specific measures to address the human rights consequences associated with that. But to me, it seems to be a more systemic issue in the way that government has adopted technology here, and some of these simple mathematical points that you've made. Do you have anything to say about the way in which this could have potentially been stopped, or other approaches that government could have taken, noting what you said about the long period of time that advocacy has been sitting around this?
Yeah, well, look, I guess, and this is my naivety showing, right? Like I've been in technology for a long time, been involved in community things for a long time, but I wasn't active in this space as an activist by any means. I didn't, I conceptually understood digital rights, but I didn't really realize anything about, I wasn't involved in EFA or anything like that. So I certainly had this expectation that when you show the harm, you show the issues, you show that a system is not working, and you can provide evidence, commentary, feedback, whatever from experts that are also like, actually, we've got some problems here, that at that point, we would have a responsible government and a responsible democratic process, governance process where, someone would say, whoa, okay, we had no idea that actually someone had messed up this badly, and, let's stop it, let's figure it out. And just, I even had an expectation that a minister might lose their job over it, because it just seemed so logical that the level of incompetence here, or whatever it was. And someone kind of challenged me on that at a certain point early on. They said, was this incompetence, or is this, a philosophical assault on the system, on people, on welfare. And I found that challenging, because, is our government incompetent, or are they evil? Like, I maybe both. I didn't really think of it like that. So yeah, that level of distrust, but also the cumulative effects of that, and I think the fact that this was done on Centrelink, the fact that it was fair game to experiment on people that have been involved in the Centrelink system. Firstly, it meant that people that were affected were less likely to understand their rights, especially if they were still within the system, or they had vulnerability indicators, or all sorts of things that just happen. The other thing that happened, because these went back 5, 6, 7 years, you had people that had been on Centrelink when they were studying, for example, and were no longer on Centrelink. So we had people that were now lawyers, or doctors, or nurses, or and the effect of that really challenged people, and it challenged myself. Like, I grew up in regional South Australia. Without Centrelink, I would not have been able to go to university. So it really made us, well, I think made people reflect on what is the role of Centrelink? What is the role of the social welfare system within Australia? What does that do for picking people up? What is our value on it? Are we happy to lose trust in it and to see it eroded? And I think that's part of what has really frustrated people as well. And then this sense of what's next, because the next step where they started to roll it out was to people on disability pension, was to people on the age pension. So it just seems all too convenient for government to test out these technologies or these strategies on people that have the least agency to be able to defend themselves. And that's, at that intersect of digital rights and human rights, I think we should all find that incredibly offensive. It's the thing that shocks me the most is that, as far as digital rights go, is that this is such an unfunded space, that right now we are seeing all these technologies come on, we're seeing all these laws come hit the table, and there's no funding, there's no time for considered debate or discussion. There's very limited thought that's getting put into this in any real, EFA does great things, but we're all volunteers. Like, the thought that stuff gets passed because I was too busy with my kids to make sure that we read a submission, or, I feel like there's a huge sense of responsibility that's slipping by us. And the robo debt is one of the effects of that, one of the effects to government of that outrage, that we get to that point where we cause that mass destruction, and government let that happen because the way that they would rather approach any sort of digital rights policy or law is to just ram it through under the carpet with very little discussion. And we're seeing that play out. Like, I've seen that play out over the last 3 years that I've been involved in EFA.
Yeah, I think that there's a lot of very complex issues that interplay here, and potentially at the heart of it, on the systemic aspect, is the idea that a person on Centrelink, New Start, or Youth Allowance would have a consistent income to be able to aggregate the data. It's a detachment from the society and from the people you're attempting to give a foot up to. And it's a loss of what role, as you said, Centrelink actually holds in the Australian community. It should be a safety net, not something that is wrought with points where you may be deeply punished. And it takes a government that appreciates not everyone has consistent full-time employment where they appear in a room a couple of times a year and say some things that are inflammatory and then disappear back into what's called their membership of parliament. I think that it's an important thing for us to hold on to here, that government needs to understand who they're representing when they're representing people in parliament, and when legislation like this is coming into effect, understanding that their constituency may be affected in ways that are adverse to their best interests. I think over on top of all of the digital rights is that systemic issue that's crept in with a government that I would say with great respect has become lazy, and technology is the manifestation of that laziness, which isn't a course that we should be embracing.
It's also opportunistic. So the other thing, just a brief point, their Centrelink system is old, like it's an old legacy system of layers, so that it's not, it was never, it can't pull reports. I think one of the reasons why they're just going to have to pay everyone back is because we saw in the Senate inquiries that they can't do reports to see, they can't even run a report to see what the change has been from when someone was issued a debt initially, and then when they've had that change, to see what the changing levels are. They said they had to manually open it, they took a sample of people's files. They had to manually open each file and, jot down the information that way. So they wanted to put a system in place. They wanted to put a practice and a data matching process in place when the technology, the data, the structures didn't exist for it. So instead of waiting, whereas now they're doing ongoing payroll update, single touch payroll systems, where then at least there would have been more real-time information that was more accurate coming from the ATO. Instead of waiting and saying, well, we'll start this program in 2022 and we'll go about it the right way and we'll design it the right way, they just said, we can retrofit this in. So that approach is also that approach of expecting more than you can actually get with your technology, because on paper it seems good, just misses all of the other risks and human impacts. I think we kind of see that with some other technologies like facial recognition and things that just sound really nice on paper to some people. If you're a salesperson, you can kind of sell it, but until you really get to the impact of what that is, and the legislation and the regulation catches up with it, and you think about the human lives, all of a sudden the can's been kicked down just that bit too far down the road, and you're starting to cause mass destruction on individuals.
Yeah, I'm conscious of the time on this, and you've just
I didn't want to.
A question we had about who's actually in charge of the technical capability and the data matching itself. I wanted just to make a point on that in terms of some of the work that we're doing with Electronic Frontiers for our audience benefit. And that is, as a long-standing contributor to the Human Rights Commission and Santow's Human Rights and Technology Project, which is a project that was launched several years ago by the Human Rights Commissioner. I think it was his first project that he had undertaken in Australia. And we've made 4 substantive submissions through this process. And at the core of that submission has been the need for Australia to have an enforceable Federal Human Rights Act. So we have a check and balance that's easily attachable to issues like this. And we've also highlighted significant issues that exist in relation to the implementation of technology. And from my perspective, which is informed by a legal background more than anything else, this is an area that's particularly riddled with complex legal issues, because the administrative law framework that sits around this has been designed and developed with a human focus, the human decision maker being key, and the decision being made by a human that bespeaks finality being fundamental to administrative review of decision making. These automated decisions are coming through in legislative frameworks that are not consistent. So, for example, the human services legislation is not consistent with the language of the migration legislation that allows automated decision making, or the intellectual property regimes that came in 2 years ago that allow for automated decision making with respect to, say, for example, trademark registrations. The lack of consistency bespeaks an issue in this process as well. The government hasn't quite grappled with this. And I find it particularly concerning that, as you said, Lyndsey, using disadvantaged people or people who are recipients of age pension, for example, an instance, as the test bed for this kind of technology is woefully unacceptable and completely should be the most heinous thing that our government could possibly do and be held to account. And I think that's the important thing we need to do with this, is continue to hold the government to account and not allow this simply to be well, you'll pay back money and therefore it can all go away. Lives have been lost in this process and significant hardships happened, and it's not something we should tolerate. Which ties into another question that I had for you, and that's to do with the outcomes that flow from this. Royal Commission has a very valid and viable base in Australia in terms of scrutiny in a public sense applied to issues in the way that certain actions have been undertaken by government or other bodies. It seems that robo-debt in this saga is a prime candidate for that level of scrutiny. Do you agree? And what do you think a Royal Commission could achieve for the robo-debt?
Yeah, I guess, from a legal perspective on whether or not a Royal Commission is the best mechanism, that's not something that I'm qualified to answer. The strategy from the legal organisations that we do stuff with is, firstly, people have to be held to account on this. Humans made this decision at every point. As much as we've got automation in here, we've got humans, we've got ministers, we've got managers, we've got people that made the decision, to lawyers, to do it, to keep going. And if we don't get to the bottom of understanding how that happened or to create any sort of accountability, how can you have $1 billion program that fails, that has to get repaid back, that causes this harm, and not have any accountability or not have any learnings from it, or not have anything that puts anything into place on where we go next time with all of this? So a Royal Commission, I guess, is a mechanism for that, and for uncovering that. So that seems to make sense. It also seems to make sense from a public. We talk to people all the time, every day, that are asking about what happens here and where is the accountability. Like, they've been asked to jump through hoops. They've been asked to go and get 7 years worth of pay slips and upload all this stuff, and now they're being told, well, actually it was illegal in the first instance. So they've had to deal with all this stress, and now they're saying, well, and what? People just get away with it? Like, people just, get Order of Australia medals and get pay rises, and it's outrageous. So yeah, it certainly has to be something, and so it certainly has to be something. So because the other legal organisations are backing the Royal Commission angle, then that's something that we're favourable of. But I'm aware that there are some other mechanisms that may also be useful as well. I just think accountability is the key thing that we want to achieve here.
An excellent comment to that effect, which I'll quote: "Ministerial accountability, surely you jest." And unfortunately, I don't disagree with that comment. I personally back the concept of a Royal Commission here, and think that this is something that all Australians should call on. There is a lot hiding under a rug here that should be exposed, opened up, and made very clearly publicly available as to how this happened, so we can ensure that these lessons are learned and not repeated in the future. And I have a question along similar lines that, Lyndsey, in my view, this is like many of the human rights and digital rights issues that we deal with. It's a balancing act, and it's a complex balancing act. At the one hand, I acknowledge that technology is and will continue to be deployed by government, and that if it's appropriately managed, it can be very beneficial. On the other hand, and this is unfortunately where we seem to be placed more often than not, the consequences of poorly implemented and non-transparent systems can have hideous and horrendous outcomes. How can a government expect trust when the heart of the issue with robo-debt, and notwithstanding other issues such as the surveillance culture that's been pushed around this, was a simple failure of acknowledging and acting upon expert advice in relation to the areas that would form as an operational aspect of this platform, specifically calculating income from aggregated data held by the ATO? How does government expect trust, and should Australians be trusting government around this?
Well, you know, I don't think there's a strong basis for trust in this. There's been far too much wrapped up in it. Oh, sorry, I lost my point. You know, I think the thing to remember, and the thing from say the digital rights, you know, the thing that gets me about digital rights and technology, I mean, most people that are involved in EFA are technologists, so it's not like we're anti-technology. We love technology, and technology used well and technology used appropriately is, you know, it's what most of us are here for. We all find it exciting. And a lot of the issues that we're going to be facing going forward are, you know, as we've got an aging population, or as we look at health budgets, a lot of those, there is a lot of community, social and economic benefit to be gained by using technology in an appropriate way. What I really love about EFA, and when I sort of talk about EFA as an organisation, is really that when people were building the internet, they also said at the same time we need to preserve people's rights. And that human rights are equally as important. And so you have technologists that have the whole time that have been saying we love the technology, but we know that this can cause mass harm, and so we really have to have rights at the heart of this. And so you have people that have been working in this area for decades with these two things that are seen as complementary. So huge amounts of expertise. The problem when you've got governments that ignore those expertise, is you just silence any conversation or any participation around it. So you end up with a public service where you don't have as many good internal advocates that are technologists that are understanding the rights and understanding the legal framework and how technology is going to be implemented. So there is no opportunity to get those benefits when you're not talking to the community. And we have this really active exclusion at the moment. So anyone that was an agitator against robo debt was seen as, you know, pushed away by the government. There was threats that, you know, that feeling of their privacy would be invaded, or they'd be doxxed, or, you know, we've got people that have worked on the Not My Debt campaign that just won't reveal who they are because they are worried about the personal impact that might have. So we've created those conditions where it is an us and them situation, where we can't have strong consultation processes where governments and administrators within government, civil servants could be benefiting from the knowledge that's out there, and really progressing this in not just a national way, but an international way, because a lot of these things at an international level are either being played out as well or are being discussed as well, or they are interconnected. So we can't, you know, acting like government can just control the internet and hold out the technology and and keep everyone out of it, is just, you know, it's part of what's causing this perception of division or actual division in some ways as well.
I think that us and them mentality and the dangers around that is really important. It's not us and them, it's those willing to assist and those unwilling to listen. And unfortunately, those unwilling to listen find themselves in government and find themselves heavily entrenched in the system that continues to conspire against itself, in effect. There's a interesting comment we've got that trust isn't like a tap. You can't just turn it on and off. And for government to have had this saga and then to turn around and say, oh, download the COVID Safe app, you can trust us, yeah, is a little bit rich. Although we have the assistance and access legislation now, and government's view on that is you can trust us not to abuse it. We don't need legislation that specifically prevents that, like a Human Rights Act that's enforceable at a federal level. Trust is something that's hard earned and easily lost, is a maxim that I was told a long time ago, and it holds true. It is hard to earn trust, and it is easily lost. Unfortunately, government seems to lose the trust more than it does earn it, and I think that may be something that's an important takeaway from this session in terms of what we do from now and where we see the future go in terms of not only robo-debt, but other automated systems used or deployed by government. which I think is a good place for us to land to a conclusion, Lyndsey. And I've asked this question of all of our previous panelists, so I'll ask the same to you. If we now place ourselves in the year 2050, which is scarily only 30 years into the future, and we look from that footing of 2050 back to what we're talking about today, do you have advice that you could give from 2050 to us today in 2020?
Yeah, look, I think that the first bit of advice is that these are not fringe geek issues. Like, you know, I think that we're now at a point where the discussion around privacy and, oh, we've been giving it up to Google for years, so young people don't care, or people don't care. At this point, there is a sense of privilege that is clear when people are pushing that thing. It's like, okay, well, just because you felt comfortable giving it up, it does not mean that the next generation is. When I talk to people about this on the playground, or parents at schools, or, you know, stuff about the COVID Safe app, in the mainstream, people have now had so much exposure to technology that just in their day-to-day lives, that they see how this is encroaching. So these are very mainstream issues, and more they will become mainstream issues. And robo-debt was an example of that. People can talk to it now. They can talk to algorithmic injustice. They can talk to the effects on the social welfare system. It's being humanized. So I think that when we get to 2050, if we continue with this same approach, the questions will be, you saw how humanized it was. You saw that people cared about these issues. You saw the impact of automation and digital rights, and where the problems with how laws were being created, and you still didn't put resources into it. You didn't put thought into it. You didn't put time into it. You let councils, you let people get ahead of community standards and conversation and expectations. I think that you took the rights away from people, and you sold that, if we continue with the same trajectory that we have at the moment. And I think people will be really offended by that, because they'll say, hey, you had your point in time where you could have really made a difference, and you could have used technology for good, and you could have been good stewards of these laws, and made sure that people were protected, and you put their rights first, and you didn't do it. Why? Because, politically there was no budget, or they just wanted, they didn't want the uncomfortable conversation because they were old and couldn't talk to the tech. And we will hopefully see that become more and more of a political issue, and we will see more and more people come through that are very informed, that really care about this stuff, that are implementing it internally within their own organizations and businesses, because they now have more examples and more language, and they know how friendly these geek organizations are, and how much willingness and openness there is to share information and to share knowledge. So yeah, I mean, hopefully we're either really, really joined up and really strong, or we just let cats out of the bag and we caused a big fat mess and the whole planet's burning down because we also ruined climate change action. And, hopefully not. I'm an optimist, so.
It was a very, very interesting mixture of optimism.
Doom! Yeah.
I hope from this session it's tooled up our audience with at least some conversations in relation to robo-debt and some of the issues that sit around this. And I'd like to conclude by thanking everyone who's joined in and the excellent questions that we've had. As Lyndsey has said through this presentation, as I started out, this is a conversation that should continue. This is a live issue, and we should continue to hold government to the highest standard in relation to the use of technology, and make sure that this isn't lost in the media cycle, but remains a relevant issue to and through the election process, because this is a crossroads in many senses of what we consider to be acceptable behaviour on behalf of a government. I'd also like to thank, in concluding, the team at ThoughtWorks who continue to power these presentations. Their technical assistance and the ability for us to do this on a decentralised basis and across the country is an enormous value add to the process that we're doing. But I'll leave you all to your afternoon, Thank you again for joining in. I look forward to the next EFA talks. Thank you.
Thanks all. Thanks for coming.